Good morning. Is that you, Miss Villavicencio?
That's me.
Okay, you can take your mask off. Let me get situated here. Um, okay, I think we've got our file aligned here. Good morning, everyone. Good morning, Bettina. Good morning, Mr. Hughes.
Morning, Judge.
I'll explain a little bit. We didn't, I'm turning the record on, we didn't have court yesterday because the power went out. And I was here about 10 after 7 yesterday. No one was here yet. The bailiff wasn't here. I walked in, everything was dark, couldn't turn the lights on. Computers didn't work, so I called Central Dispatch. Said, hey, the power's out at the courthouse. And they said, the power's out everywhere.
They got the other people in the courtroom right now.
So, Mr. Walker, I'm going to mute your microphone. So we tried to figure out what was going on and got a hold of the administrator and the chief judge, and we stalled till 10, and then we stalled till noon, and then they just called the whole day. So we had no court yesterday, so fortunately we're all here ready to go today. It's hard to accomplish anything. Once upon a time we could do court with paper files and a stenographer, but now that everything's electronic, you can't do anything, and the air conditioner doesn't work. And when I first started, we didn't even have computers, so that was a long time ago. Anyway, we're all here today. Miss Villavicencio is here today. Mr. Walker, I muted your microphone. I'll bring you back in here in a little bit. Your case isn't set until 9:30. But let's go on the record. Our first matter is Village Court Mobile Home Park versus Diana Villavicencio. She is present here in the conference room. Mr. David Hughes is here. We had a previous hearing, I believe on April 23rd, and the matter was continued until today. So this is the second hearing. This was filed as a demand for non-payment of rent. At the time of the filing, it was something, but now it's changed. Mr. Hughes claims through June rent is $3,300 for lot and mobile home, late fees of $30 per month, utility bills of $512 for a total late rent and utilities of $3,902.57. Bettina Emery from Keystone Place is here with us on the feed this morning. Good morning. Mr. Hughes, what's the circumstance here?
So, Your Honor, my understanding is that Ms. Villavicencio has not made any payments to my client. At the previous hearing, I believe Keystone said that they were in the process of providing rental assistance, and they had me send over first they sent a letter with the court costs. They said they needed, then they said they needed an actual judgment. I said, well, judgment is entered, so I just did kind of the proposed judgment without your signature showing the numbers and sent it to them. But my client says they still haven't received any funds from Keystone either. So at this point, we'd ask for the judgment of possession to be entered.
Bettina, what can you tell us?
Your Honor, the finance department has issued checks last week, so the check should be on its way to the party.
How much is it?
4,415.
So does that pay through June?
I believe so, Your Honor.
Ms. Villavicencio, you and I have met a number of times over the years. What do you know about this?
Well, he did send me a letter and I went to Keystone because I'm not working right now. And I've been trying to, I'm looking for a job. And the reason why I wasn't working because I was in a bad car accident. So I was on restrictions and I could not work. And the doctor just released me on 20-pound restriction to go back to work. So right now I'm in the process of looking for work.
All right, well, you're a nurse, aren't you?
No.
Oh, I thought you finished the nursing program.
No, I didn't finish the nursing program.
Okay.
I've been working in the factory field.
Okay, well, did you go to Keystone and apply for assistance?
Yes, I did.
Okay. Well, David, I'm not sure what to do here. If I did a writ, it would be 10 days from today, and it sounds like this is a classic case of the check's in the mail, but it's coming from a reliable source, which is Keystone, our local HARA. What's your thought regarding this?
Well, again, if the check was mailed out last week, I would assume my client should be getting it any day. If there does wind up being some issue with the payment, I would prefer it not drag out any longer. So again, I guess my preference would be to have the judgment of possession enter. Obviously, the moment my clients receive the funds, they're not going to move forward with an order of eviction. And if after 10 days they still haven't received the funds,
Well, all right, if there is a request for a writ, I guess I could have a hearing. Ms. Villavicencio, I'm going to make a finding that through June, you owe $3,902.57 in rent, late fees, and utilities. Court costs here are $167.92. Total due is $4,070.49. The check that Keystone has cut is more than that. I'm going to do this order saying that you have to pay that amount of money within 10 days. 10 days from today would be June 7th. Excuse me, June 7th. I fully expect that the matter will be paid. Partial payment will not prevent the writ of eviction. Now, if it isn't paid and there is a request for a writ of eviction, I'll set it for further hearing. I'm not going to do a eviction till we have further hearing. But when they get the money, they can dismiss the case. And Miss Emery works with us all the time. She's reliable, although it takes a while. We've adjourned this 30 days and the check still isn't there, but I expect it will be paid. I also appreciate your diligence to come over here to the court to take care of this. So I suggest you stay in contact with your management and you stay in contact with Keystone.
Your Honor,
Mr. Yes?
just to be clear, I wasn't questioning Miss Emery's honesty there. You never know what's going to happen, so that's why I was.
I didn't accuse you of that. You've worked with her too. She's good for her work, but it's a bureaucracy and things don't always work the way they should. So, but Ms. Villavicencio, I fully expect this to be paid. Diana, do you have any questions?
No.
All right. Stay in touch with Keystone, stay in touch with their management. She said the checks were cut yesterday? Is that today?
No, last week.
Last week, so they should be there any day.
Yes.
Okay. I'll do the order, but I won't do a writ without having a hearing, and I don't expect we're gonna need that. All right, Ms. Villavicencio, you're good to go. Good luck on finding your next
Thank you.
employment. Okay, bye.
All right, bye.
All right, let's bring in Tom Becker. David, that's all you've got this morning, isn't it?
It is, Your Honor. Thank you. Have a good weekend.
All right, you too. Thank you. Good morning, Mr. Becker. We haven't seen you in a while.
Morning, Your Honor. How are you?
Good. Are you covered for Bradshaw today?
I am.
Well, that's a rare occurrence, but I haven't seen you in a while. Nice to see you. I've been here all day, every day, but you've been otherwise occupied. This case, Sanders, is set for 9:10. It's now 9:08, so we have to let the clock tick for a bit. Mr. Walker, your case is set for 9:30, so stick around. You're in the right spot. This is also a Keystone place. Tom, I don't know if you've met Bettina Emery, but she's our housing advocate from Keystone. She's with us essentially at every landlord-tenant hearing. Bettina, what do you know about this one, Edgewater versus Shamika Sanders?
For Ms. Sanders, the check is in the process of being cut in the amount of $1,320.
Mr. Becker, why don't you go ahead and place your appearance on the record?
Thomas Becker, appearing for Edgewater Place Apartments for John Bradshaw. Yeah.
It is 9:10. When we were here in April, the arrearage was $1,012.78.
We're sure. Oh, I'm sorry, Your Honor. Go ahead.
Here's the manager from Edgewater.
Here's the, I had to turn it on. But it was the wrong number. I had to call the courthouse.
Oh, good morning, Edgewater. I can hear you.
I just turned it on. I don't see.
This is Judge Middleton. Can you hear me?
Yes.
We're talking about Shamika Sanders. She's not here. Bettina from Keystone indicated they have cut a check in the amount of $1,320.
The process.
And it's in the process. Edgewater has yet to receive any check.
Not yet.
What's the arrearage now through June?
Showing a rent to retain possession of $1,270, costs of $166.41 for a total of $1,436.41.
I don't have a judgment. So I'm going to, and Shamika isn't here. She usually shows up. I'm suspecting maybe that she thinks it's been taken care of. So I'm going to do those numbers, 1270 through June, 166.41 for a total of 136.41. The check, according to Bettina, is $1,320, so there's about $150 shortfall will need to be dealt with.
I believe that number is May.
through May? Okay.
That, we have 1410 right now, and that's not including any court costs.
All right. Well, I'm gonna do this through May. Is Miss Sanders still there?
Yes, she is.
Well, she's not here, and I wish she were, we could discuss this, but go ahead and, this happened in the last case. Keystone had cut a check, which was for more than the amount of the rent, and they expect it to be there, so we don't really expect to be issuing the writ. In this case, there's a bit of a shortfall even through May. Then we get into June, and we've got all other problems. But I'm going to use your number, Mr. Becker, 1270 through May, 166.41 in cost for a total of 143641 through May. The check is in process. We'll see what happens, but in order to stop the writ of eviction, the entire amount has to be paid. So there needs to be some further communication. I don't know if you're going to do this or they will, but we'll usually, Mr. Bradshaw, Mr. Fleeman, simply email or fax a judgment.
We'll do. I can send a judgment, Your Honor. Do you have the address I can send that to by email?
Yeah. I don't want to put it out.
Oh, certainly. I can call in, Your Honor.
Yeah, that's fine. Okay, anything further on that case?
Yeah, if I may, just for my property manager at Edgewater, the differential has to do with a difference in filing fees, and we had to reduce it by 140.
All right. Well, we'll see. Yeah, they have 1410 and you reduced it by 140. All right, so we'll go with 1270. All right.
Thank you.
All right, you'll submit a judgment. All right, thank you.
Thank you, Your Honor. Take care.
Okay. Edgewater, we'll remove. Good morning, Mr. Thornton.
Good morning, Judge.
You're all masked up. You look like a room full of desperados there,
Yeah.
so. This matter is set for 9:20, and it is 9:20. I'm surprised that legal aid and Mr. Kloppenstein aren't here yet, so let's wait just a moment.
Yeah, I've only got 9:16, so.
Oh, you're right. The clock stopped yesterday when the power went out, so it's all screwy. It's 9:16. You're right on the computer. I was looking at the clock. It says 20 to 8. So we had quite a day yesterday because we stumbled around waiting to see whether the power was going to come back on, and we went to 10 and noon. And so it was quite a disjointed day, and anybody that wanted to find out what was going on, the computers weren't up, the phones didn't work, so there was a lot of confusion. Although it's not all that uncommon. In the years I've been here, that's probably happened 20 times. We've lost power due to a storm in the summer or winter. Or I don't even know what happened, why power was out. To this moment, I don't know why on a sunny May day 3,000 people lost power, but maybe someone forgot to pay the bill. I don't know. Here's Rebecca Johnson from Legal Aid. Good morning.
Good morning, Your Honor.
We're discussing what time it is because none of the clocks here work at the courthouse, but the computer has a clock on it. We'll operate from that one. And wait just a minute. Do you expect Mr. Kloppenstein to be joining us?
I do. We did just get off the phone.
Okay.
And would you mind if I inquire about another case we have this morning?
Certainly.
Regarding the Acevedo v. Booth case, the court should have received our conditional dismissal, so there'd be no need for the hearing.
I have not received it, but that's good news.
Okay.
It's probably in transit. It'll be brought in. So that is set for 10. And the Trade Winds versus Morris 940 is dismissed. Our next case, Mr. Walker and Ms. Laffler, is set for 10:30. That may be a bit delayed. Well, good. You can bring me good news whenever you like.
Great.
And I won't shoot the messenger if you bring me bad news, but I prefer good news.
There was an electronic filing for Booth and also one via postal service, so they're somewhere.
Okay, I'm sure Bettina probably has it. I mean, Guadalupe probably has it, and I'll get it here shortly. All right, Mr. Kloppenstein, you got 2 minutes. Why don't you come join us? Here he is. Good morning, Mr. Kloppenstein. Is that you?
Yes, it is, Judge Middleton.
Can you hear me?
Yes, I can.
All right. Do you have the ability to do video or just phone this morning?
Just the phone, Your Honor.
All right. Well, let's call the case. Everybody's here. This is file 20350LT. It's entitled Ronald and Carol Schroeder versus Craig Kloppenstein. This is the oldest landlord-tenant case we have from the COVID circumstance. This was filed as a non-payment of rent case last February of 2020. It was alleged that rent was $575 per month, and it was paid through December of 2019. So the plaintiff is claiming no rent paid through all of 2020 or 2021. We had a hearing at the very start of the COVID circumstance in February 24th. The shutdown actually occurred about March 10th or 11th. So we had a hearing on February 24th. I made a finding that through March of 2020, defendant's rent was $2,300 plus costs for a total of $2,596.50. The date for the writ was by March 5th. Well, the plaintiffs didn't request a writ, and then the stay happened. So we had another hearing in August of 2020 where I made a finding that rent was $2,749 plus costs for a total of $3,090.50 with a writ date of September 3rd. Well, then another stay was entered, and we spent a lot of time on these hearings. And then another judgment entered after that. So essentially, this has gone from stay of writ of eviction to stay of writ of eviction. Deborah Davis was the attorney of record for the Schroeders, and she's since left her private practice and joined the prosecutor's office. So the Schroeders have retained Lance Thornton, who does a lot of landlord-tenant work, and the defendant has obtained the services of legal aid, and Rebecca Johnson is here from legal aid. So right now, this matter is still theoretically subject to the CDC stay, which extends through June 30th. It is a non-payment of rent case. The plaintiffs have been trying to evict the defendant since last February. It's now May of 2021, and he's still there, and there's still a stay in place. Mr. Thornton filed a motion to reopen the case, alleging new issues, which are termination of tenancy type issues. But this is a non-payment of rent case.
Actually, Your Honor, I did not file that. My understanding is that was drafted by Ms. Davis, but signed by the Schroeders, and that was all done before I got involved.
All right, so the Schroeders filed that. Thank you, Lance, on their own behalf. Lance is here now. I did inquire of Bettina Emery about this last week, whether there had been a request for any financial housing assistance from Mr. Kloppenstein to Keystone. Her indication at that time, I guess this is probably ex parte evidence, we'll see if it's correct. Her understanding was Mr. Kloppenstein had applied for assistance, but the Schroeders were unwilling to participate. So here we are. So Mr. Thornton, I'm glad to have him here. He's an experienced landlord-tenant counsel, and the Schroeders, I think, need some help. So, Mr. Thornton, what's your position here?
Your Honor, I'll address that first, the whole issue with Keystone. It's my understanding that the Schroeders have for a long time now had someone who wanted to buy the home. That's why they wanted to evict Mr. Kloppenstein so they could sell it. The buyer does not want a tenant in the home when they buy it. It's my understanding the buyer wants to live in the home. But so that was from the Schroeders' perspective, I think it was a case of somewhat of a misunderstanding. Keystone wouldn't pay the money unless they would agree that Mr. Kloppenstein could stay at least for a period of time. And their goal was to eventually get Mr. Kloppenstein out so they could sell the home. And that's the problem that developed with Keystone. I know there are some allegations I interpret from Ms. Johnson's response to the motion that the Schroeders have refused other partial payments of rent or rent payments. They haven't. They tell me they have not refused other than the what's happened with Keystone. Currently, I've advised the Schroeders that I think the best resolution here would be to come up with a date by which possibly Mr. Kloppenstein would move out. And if Keystone was able to pay some of this back rent, which my understanding is there's over $7,000 owed at this point just in rent.
What is the current arrearage as best you can tell?
I've got $7,425 through May, the end of May.
When was any rent last received?
July last year.
Mr. Schroeder's indicating July of last year, 2020.
And Your Honor, I have not seen any ledgers. I know some partial payments have been made, so I would want to see a ledger, but we've also discussed continuing to work with the SARA program as well to resolve this issue.
All right, well, the problem here is the plaintiffs all along have wanted to sell this house. There's someone that's been waiting to buy it since last February, as I understood it, because they were gonna move into it. And it got filed as a non-payment of rent rather than a termination of tenancy case. And there we are. Mr. Kloppenstein, here we are under this circumstance. Have you made any effort to try to move?
Yes, Your Honor, I have. Well, first I'd like to bring to the court's attention this fact.
Mr. Kloppenstein, I would advise you to just answer the question the judge asked.
You've got an attorney. I know that you like to represent yourself sometimes. All right, all I'm going to ask you now is, well, have you made any effort to relocate?
I'm trying to answer that. Yes, I have. I actually had a place which I left ex parte communication to you a year ago that I was pretty much hoping to get this trailer over in Centerville. However, even though I pretty much had the place to where I was going to be able to get it, when I called Schroeder's, I explained to Ron, I said, I need a reference for the last several years. They need a document from you indicating that I've paid rent. I said, but if we bring in this eviction stuff, it's going to nix everything. He said, okay. So he supplied me with a 1-paragraph thing saying that I've been here for the last 8 years and paid rent monthly. I tendered that to the prospective owner of the trailer park. They in turn called the Schroeder's, and from there Schroeder's proceeded to run me down. So I got turned down on the place.
Yeah, you left a note on my truck telling me what you were doing, which I made part of the file.
Yeah.
Well, that was a year ago. Have you had any success since then?
I have been out every day looking. My pasture, I've got 3 real estate agents. I've got several other people in the process trying to find a place. There's about a dozen of us that's canvassing and have not been able to find anything. I am at the threshold to where now I'm looking at trying to contact motels to where, if need be and if necessary, I can go into a motel and put my stuff in storage until I can find a place.
Well, one of your problems is your affinity for cats, and it's cost you previous tenancies because you have cats and lots of them. What's the status now with your cat situation?
What's the status? I've got 12 cats. They're all deemed emotional support animals.
Well, deemed by you, but no tenant really wants to take somebody in.
They're deemed by medical doctors. I've got medical doctors' letters, and at the time I signed my lease, I gave the Schroeders a copy of each of those medical letters from my doctors.
Well, nobody wants you as a tenant because they don't want 12 cats or 52 feral cats outside. And so the landlords know of this, and it makes it hard for you to find another place to go. So that's why I was asking whether you had a plan to go with your cats.
Well, my cats go with me in number 2. The cats, the Schroeders have blown this so far out of proportion. There's no feral cats whatsoever. And there's no cats other than mine, and every one of mine has been fixed. And I've had mine, every one of them, the least amount of time for the last 7 years. Some of them are 15, 16 years old.
All right, well, the issue is you're living there, they want to sell their house, somebody wants to buy it, you're not paying any rent, you're not moving, so we're up against the proverbial rock and a hard place. You've had the benefit of living there since more than a year when they've been trying to get you out because of all these stays. Rent is now $7,000 give or take in arrears, and you haven't paid any rent since last July, and there you are and there they are. So Mr. Thornton and Ms. Johnson would like to work out some sort of an accommodation. Now, in the background is Keystone, who paid some of your rent, I think. And now they're saying, well, we could pay his rent, but the landlord wants him to move anyway. So it isn't going to be a eviction diversion. Maybe the money would be better spent with something else. And really, the only way you're going to go out of there is by court order. You've been trying to find a place to go for a year and a half. You've paid no rent since last July. It's now almost June, and you haven't found a place to go. And the only way they're going to get you out of there is to pry you out by your fingernails, and then they can sell the house. But that puts you and your cats out on the street. So I'll defer to you, Ms. Johnson. Do you have any suggestion in light of Mr. Thornton's proposal?
So, Your Honor, after speaking with Mr. Thornton yesterday, it seems like there may be some willingness for all parties to work with this SARA program. It's going to really depend on what type of agreement or arrangement we could reach, depending on the numbers we receive from SARA and regarding what backload rent could be paid, if future rent is available, and possibly determining a move-out date. In certain cases, if a new landlord accepts future rent payments, a move-out date can be set according to the new SARA MISHDA guidelines. I've worked on several of these cases already, but it's really going to depend on what numbers we receive from Keystone to see how and what arrangement we could provide there. We are looking to settle some of these judgments and clear those out, but also make sure that Mr. Kloppenstein is housed as well. So I do think something can be reached, but we have to permit the cure in a non-payment case to go forward, because this is not a termination case.
All right, Bettina, do you have any input on this?
If the landlords are willing to participate, we would be able to provide some back rent for Mr. Kloppenstein.
And Your Honor, that's the key. Two issues, I guess: the amount that Keystone would be able to pay, and how long the Schroeders, quite frankly, would have to agree to let Mr. Kloppenstein stay. Just to be upfront, I was waiting through today's hearing, but we will be issuing a notice to quit and heading towards the filing of a new termination of tenancy case, unless we're able to resolve and get a termination date sometime in the future as part of these proceedings.
And Mr. Thornton, I would ask that you hold off on that due to SARA funding restrictions on when a new notice to quit could be filed. I don't know how long it would take us to get those numbers, but so that that money could at least be figured out so we can work that out would be in everyone's best interest, I believe.
Well, here's another issue, is the CDC stay expires on June 30th. And there's a strong argument that the CDC, Center for Disease Control, doesn't have the authority to grant such a broad-based stay to prohibit landlords from evicting clients. Some judges in other states are frankly just ignoring it. Maybe even some judges in Michigan are ignoring it. There are at least 2 federal court opinions that said CDC does not have the authority to grant such a stay, and that's on appeal. But the only reason Mr. Kloppenstein is still there and has not been evicted is because there have been a series of stays, either from the Michigan governor's office and then some federal stuff, and now this most recent one. Each time, I remember last April, the defendants, or the plaintiffs, were ready to get a writ of eviction as the stay was supposed to expire on April 30th. Then it went to June 30th, and it went to September 30th, and there was another one. The stay kept being extended within hours of when it expired. So theoretically, this stay is going to expire on June 30th. But people are concerned about having a tsunami of people ready to be evicted after June 30th. So I don't know whether there's going to be some other stay, legislative or otherwise, but absent some other administrative or legislative stay of eviction, the Schroeders will be able to ask for a writ on or after July 1st without doing anything, saying the rent hasn't been paid, I don't have to participate in the program, the rent is way in arrears, there's already been an order, and the only reason it hasn't been issued is because of a stay. Now, as I said, we don't know whether there's gonna be another stay. So that's in the background. Ideally, something could be worked out where the Schroeders could get some emergency housing money to pay this substantial arrearage, and the defendant could find a place to go. But he's been looking for a place to go for a year and a half. And he wrote me that note on my truck last spring. And I thought perhaps the problem would be resolved, but it wasn't. So that was last June, and here it is June a year later, and he still hasn't found a place to go. So everybody's backed up. The plaintiffs aren't getting any money. The person that wants to buy the house can't buy the house. So here we are. So what do you propose? You're both talking about some sort of a attempt at a resolution. Could we continue this for a couple weeks and see where the parties are at that time? What's your thought on that, Mr. Thornton?
I can talk to my clients quick. If we could, the sooner the better to get back in, and the least amount of adjournment would be great. We're going to have to make that decision. I understand what Ms. Johnson.
Well, right now, I'm not inclined to grant the writ of eviction. The stay's still in effect. Mr. Kloppenstein has made efforts to get funding. Mr. Thornton did a very comprehensive hearing a few weeks ago with some tenants that weren't paying the rent, and they were making $120,000 a year. And he established proof that they just simply weren't paying. So then finally they just agreed to move. But I think there's going to be at least a good faith showing that Mr. Kloppenstein has tried to get assistance, and for whatever reason it hasn't worked. So if we adjourn 2 weeks, it'll give everybody a chance to see if they can meet some middle ground. Ms. Johnson, what's your thought?
Your Honor, I would ask for the 30 days because the SARA application has been put forward, and if the Schroeders do decide that they do not want to participate in the program, the funds would go directly to the tenant so that payment could be cured and that a judgment could be resolved. So regardless of if the Schroeders decide to participate in the program or not participate in the program, as long as they agree to accept rent and the cure for a non-payment case as permitted under law, I say we continue and ask for the 30 days so that Keystone can process.
Well, he's already had a year and a half. And so you're right, if he wins the lottery and gets a bunch of money and he just pays cash and pays the rent, then he's good to go till the next month. But then you're waiting for them to not file a writ of eviction. So what you're saying is, we're going to try to get the money and pay the rent. So please don't file the termination of tenancy. Well, they want to terminate the tenancy. They want to sell the house. And so Honor, you want it both ways.
So, Your Honor, I'm very aware of what the Schroeders will probably do next, especially with Mr. Thornton now being involved. I'm asking that the court enforce the cure for a non-payment case that is permitted in non-payment cases. My client's been, in part, denied the opportunity to seek a full cure in his case.
Well, I don't know about that. The last order was supposed to enter, we did this twice. We did one in February and then we did another one in August. And by that time, a 30-day extension, the stay will be up. And they don't need to do anything. And I suppose if the stay is up and Mr. Kloppenstein pays $9,000, his tenancy is good for one more month. That would get him through June or July, and then the Schroeders are gonna file a termination of tenancy action. So it could stall them through July and maybe into August. In the meantime, defendant would move if he had somewhere to move to. And that is a common refrain. I think I'll get a t-shirt made that said, I would move if I had somewhere to move to, because I hear it every week. Anyway, Mr. Thornton, what's your thought regarding their request for 30-day?
We would oppose that, Your Honor. We might as well file the notice to quit, get that 30-day period running so that we can file the new case. I don't foresee a big payment coming through at this point, and I think the Schroeder's downside is more of leaving Mr. Kloppenstein in there. I believe those 12 cats are indoor cats, and the home is being significantly damaged. Mr. Kloppenstein refused a recent request to go in and inspect. So I'm assuming the situation is not good.
And Your Honor, I would like to correct the record. If 2 weeks is amenable to Mr. Thornton for him and I to possibly work on an agreement to get some numbers from the SARA program so that we can resolve that, I would ask for that. I just know there is a scare order issued when SARA funds and programs become involved, which is something I know courts have been pretty adherent to complying with. I do want to note that the complaints and allegations of the condition of the home were not pled originally. In the non-payment case, my client only refused access to the home because he was not given notice. He is more than happy to allow the inspection and has requested a repair to be made as well. He would just like there to be 24 hours notice for that to be done.
All right. Well, I'm not going to do anything. I'm going to deny plaintiff's pro per motion to reopen the case. Plaintiff is free to file a termination of tenancy case.
Your Honor, I would like to ask, is the case technically closed? Because
no, you're entitled to a writ of eviction, but the writ of eviction has been stayed because of the various COVID stays. So my last order, there was one in February, and then there was an order. There is an application and writ of eviction on file from September 4th. So the writ of eviction has been filed and it's stayed pending the COVID stay.
Okay, I just wanted that clarification that we could still file for a writ after June 30th.
It's already been filed. It's already been signed. It's an order that he move, but it's been stayed. So you don't need to do anything and let the clock tick to July 1st unless there's another stay. That writ can be then issued July 1st. So at this point, Mr. Kloppenstein, it appears you should make every effort to get out of there by July 1st. They've had a writ of eviction in effect since last September 4th, but it's been stayed by one order or another. So unless it's stayed again, the sheriff could come on the 1st or 2nd of July and put all your stuff out. So I don't think we're going to get any emergency housing money. I don't think they're going to get any money. I think they just want you to move so they can sell their house. So that is stayed. until June 30th. Until further order of the court. I don't have any way of knowing what is going to happen. These stays have come from different directions. One stay was from the state of Michigan, one state was from the federal government, then all of a sudden the Center for Disease Control issued the last stay everywhere across the whole country, which they arguably didn't have the authority to do, so I don't think that's going to happen again. The legislature, the federal government or the state government could issue a stay, but right now the only reason he hasn't been evicted is because there have been a series of stays from one source or another. All right, I'll leave it to anybody else. You guys are certainly willing and capable of talking to each other over the next month, see if something can be resolved. Plaintiffs are entitled to file a termination of tenancy in case there is another stay. But at this point, I'm not going to reopen the case. I think defendant made a good enough effort to secure funding. For whatever reason, it didn't happen, probably because partially the plaintiffs wanted the money but wanted him to move, so Keystone wasn't willing to do it. So they don't have to take the money. Now, if he comes in with $10,000 cash and pays it to him, then they're stuck with him, stay or not, unless they file a termination of tenancy. But at this point, it's status quo. The writ of eviction was signed September 4th of 2020, and it's been stayed until June 30th. We'll see what happens between now and June 30th. Mr. Kloppenstein, I'm glad you've got legal representation. Legal aid is as good as there is for tenant defense, but at some point the clock is going to stop ticking and the Schroeders are going to be entitled to get their house back so they can sell it. So we've got about a month. All right, I've got other people waiting for their cases.
Your Honor,
So
do you need an order or not?
Yeah, that would be good, I guess. Lance, I'd ask you to do an order.
Okay.
Ms. Johnson.
And Mr. Kloppenstein will happily speak after the hearing.
All right.
And
All right.
Your Honor, are you stating that if my client came to the plaintiffs with the money, they would have to accept the cure?
Well, that's a good question because the writ of eviction is already entered, so probably not. If he had $10,000, I've already issued the writ and it's just been stayed. They could decide to accept it, but I don't think they could be compelled to. All right, thank you. Mr. Kloppenstein will be in touch. Stay in contact with your lawyer. The Schroeders, I'm glad you've got counsel now as well. I know you're very frustrated, and I think there's probably enough frustration to go around in this case. All right, I'll remove the parties one by one.
Thank you, Your Honor.
Thank you.
And Your Honor, I'm happy to put the both conditional dismissal on the record if you'd like that, or if you're fine with the written one, that's fine as well.
The written one should be fine. Lapita probably has it, but thank you for the heads up on that.
You're welcome, and have a good day, Your
All
Honor.
right, thank you.
Thank you.
All right, Ms. Laffler? Can you hear me? I'm not going to call you Carolyn, but I am going to make you turn your microphone on.
I'm Marilyn, not Carolyn.
I know you are. I was pulling your leg.
Okay.
I used to get you and your sister mixed up all the time, but that was many years ago. We were both a lot younger then.
We don't want to talk about that.
She has a twin sister. All right, Mr. Walker, could you unmute your microphone? Good morning, Andrew.
Hey, I commented on your hair the other day too, but
I saw that. Neil Young, I guess that's as good as any. All right, Mr. Walker, can you hear me?
yes, sir.
Good morning, sir. This is Judge Middleton.
Morning to you.
We've met many times over the years, and good morning to you. Your tenant, Marilyn Landlord, is here.
Yes.
Let's talk about this case. This is entitled Richard Walker versus Marilyn Landlord. We also have Tyler Morris here on another case, which we're about to do in a bit. So, Mr. Morris, good morning to you, sir. Marilyn and Tyler, I both want you to listen to what I'm about to tell you.
Okay.
As a defendant in a landlord-tenant proceeding, including non-payment of rent, termination of tenancy, or other action, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our county that's Keystone, or other program may be able to help you with some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. The summons and complaint from the court are sufficient. If the plaintiff is agreeable, the Citizen Mediation Services may be available as a possible source of case resolution. If the parties are interested, the court can facilitate that mediation. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above, but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. If the judge does not find in your favor, the original judgment would stand. Now, Mr. Walker and Ms. Landlord, he is the landlord of a property at 516 Cottage Street. Rent is alleged to be $750 per month. Mr. Walker, what's the current arrearage?
About 2,200.
Through May?
Sorry.
You've got 2,250. Is that through May?
Yes.
So if we add June, the rent would be $3,000 through June, which is 4 months. Ms. Landlord, what do you say to that? Do you agree with that?
No, I do not.
Okay.
I have my rent receipts up till April 1st. That pays me till May 1st. He wants me. This all started back in March. My grandson got an accident and ended up in the trauma center at Borges. The landlord came here. My granddaughter was here helping my daughter out, and my granddaughter, youngest one. Landlord came with a woman, knocked on the door. My granddaughter Briley took and told him I wasn't here. He said I didn't need to be here. He pushed his way through, showed this lady the house. I told her, she called me. I told her to give him the phone. I said, "Who is this lady you're bringing in my house?" And he said, "It's some other name." And I said, "Who is she?" He said, "Oh, it's Laura." And he told me he'd call me later. Never got a hold of me. Come to find out, it's a real estate lady. He's showing the house. Never told me he wanted to sell it. And then he turns around and won't fix it up. Tim, the inspector, is very upset because he didn't show up for inspection in April.
All right, well, slow down for a minute. So you're alleging that you've paid rent through May?
Up till May 3rd it was due.
All right,
I
so
had
you
the
paid
rent
rent.
receipt with me.
All right, so you contend you paid rent through May 2nd.
Yes, sir.
Well, it says it's due on the 1st, so at this point, your position is you owe May's rent and June's rent. Or you will owe June's rent, is that correct?
Right.
Do you have a lease?
No, he would not give me a lease.
How long have you been there?
Since December of 2019.
This is similar to the last case where the landlord wants to sell the property where the tenant is in it. Here you have no lease. Now, Keystone could be available to help pay some or all of the rent, but we have to agree on how much the rent is. Mr. Walker, how'd you come up with your figure?
She doesn't have a receipt for April because she didn't pay April.
It's all right here.
Her friend and wanted a receipt for April, but she doesn't have one. And she needs 6 months receipts to get into her new apartment place she wants to live. And she did not pay April. And I told her I've got cancer and I have to sell the property. And she needed to put that into her mind.
All right, well then what you should have filed is a termination of tenancy action, not a non-payment of rent. If you want to get her out and sell the property, you have no lease. You just move to terminate the tenancy, give her the proper notice, and if she doesn't move, then you get the property back. Here you've asked her to pay rent, and there's a dispute. So according to you, she hasn't paid April or May's rent. That's only 2 months, not 4 months. April and May, $750 for April, $750 for May, and another $750 for July.
Your Honor?
Yes.
I let her move in with no money, and she, in 2019, she got 6 weeks she didn't pay. That's how
Yes, I did.
Month and a half.
Now stop. Only one person can pay at a time. Well, Mr. Walker, you could use some help here. What do you want? Do you want her to pay the rent or you want her to move out?
I just want her out, okay?
And so do I.
Well, you're going to love this. The law requires that I set this in a non-payment of rent case for a second hearing 30 days from today. So, Ms. Lafler, I guess you can kind of use this as a 30 days to find another place to go. The law requires that I set it for 30 days. Now, Keystone could be available to help with the rent, but he wants her out. So, sort of like the last people, they wanted him out, and we haven't even agreed on what the rent is. Today is the 28th of May. I'm going to continue this to the 28th of June at 1:15.
Now, I've been looking for a place since May or the last of April. So if I find a place and move, do I still have to show up for court?
No, if you find a place and move, and you turn in your keys, and you give your forwarding address in writing, and you move, nobody needs to appear.
Okay. I'm trying to find a place to get out.
Well, you heard what I said in the earlier case. People would move if they had some place to move to.
Right.
You don't have 12 cats, so it might make it easier for you to find a place to move to. But if you do move, then you just turn in the keys, give your forwarding address, and there's no need to appear in court. If Mr. Walker wants to sue you for money damages for back rent, we could have another hearing. But Mr. Walker, the law does require that I continue this for 30 days, which would be June 28th at 1:15 p.m. Ms. Lafler, if you move, turn in the keys, nobody needs to be here on that day, and you can live happily ever after unless he pursues the back rent. Mr. Walker, then you can list the matter for sale. You and I have been going through life at about the same rate. I think we're born about the same year. I know you've been struggling here with your illness. I wish you the best. But hopefully Marilyn can find a place to go. You can get your place back and sell it. All right, does anybody have any questions?
No, I don't.
All right, our next hearing, unless you move out, is June 28th at 1:15.
Thank you, Your Honor.
Well, thank you. All right, let me bring in some other people. But Mr. Walker, thank you for logging in early. You got to watch some other cases, which I think is good. All right. I'll remove him. I'll remove Ms. Laffler. And then I'll bring in Mr. Hilton, Mr. Littlefield, and LGK40. Tyler Morris has been waiting patiently, and I went through the rights with him. Mr. Morris, your landlord has dismissed your case, so you must have paid the rent or something. This is file 21746LT, and it's entitled Trade-Win Apartments versus Tyler Morris. The plaintiff has filed a conditional order of dismissal. Did you move or did you pay the rent?
Can you hear me?
Yes.
All right. So I have paid rent every single time, maybe a little bit late, admittedly, on a couple times, but yeah, I've paid rent perfectly on time.
All right, well then you're caught up and the landlord's dismissed the case and you're free to go.
All right.
You
perfect.
got a little bit of legal education this morning by watching the other cases, but your case has been dismissed without prejudice. I guess it could be rebrought, but make sure you pay June's rent. You won't have to come see me anymore.
Yes, sir. Sounds like a plan.
All right, good luck, sir.
Thank you very much. Have a great day.
All right, that was our 940 case. Our 10 o'clock case is Acevedo versus Booth, file 21704. Is anyone here on that case? There is a consent order for conditional dismissal signed by Joseph Hughes and Rebecca Johnson, and that case is conditionally dismissed. That brings us up to Brown v. Hilton. And Mr. Hilton, can you hear me? Sinners wanted. Not here, perhaps. Mr. Hilton, can you hear me? This is file 21706LT. It's entitled Jeffrey Brown versus Amanda Gregg Hilton and Tristan Hilton. Andrew Rognus is here for the plaintiffs. We were here on May 21st. The defendant indicated they planned to leave, and they had no power. They had a generator, and they were going to be out. And I continued the matter for 7 days to today, May 28th. You're in the same universal background you were in last time. Today is a week later from last week. Ms. Hilton and Mr. Hilton, what's the circumstance?
Okay, we have the house pretty well packed up. We have everything moved out to the garage. We're just waiting for the truck to come and move the stuff from the garage to the storage unit. And I have yet to go to Jeff's actual residence over on Mechanic Street to get my stuff from there.
Well, you have 10 days to vacate. This one, meter with a fire and the meter was pulled. I'm not gonna put you on the street tomorrow, but Andrew, it sounds like they'll be out, but would you submit a judgment?
Actually, I think we emailed it before last Friday.
Oh, I've got it right here.
Okay.
I find by hearing the plaintiff is entitled to possession of the property by June 7th. this is a hazardous property. There was a fire, there's no electricity, you're running a generator, I don't know if there's water. You really need to be out of there. But if you're not out by June 7th, the sheriff will come put you out. I think you will be out by then. I think you've been making effort to get out of there. You don't want to live in a house with no electricity.
No.
All right, if you're out by June 7th, you need to turn in the keys to Mr. Brown, give your forwarding address, but
I was there our last court meeting and I gave him the keys already for the house.
all right. Then you don't need to do anything except get your stuff out.
Right.
All right, do you have any questions?
No, sir.
Okay, you're good to go.
Thank you.
Thank you. Hopefully they can get out of there and Mr. Brown can get in and make some repairs. All right, our next matter is also Mr. Rognus. It's entitled David Persons versus Jeff Littlefield and all others. Good morning, Mr. Littlefield.
Good morning.
This is also a termination of tenancy case. In this case, Mr. Rognus contends that Mr. Littlefield is a squatter. His father was the tenant. He moved in, father-in-law. He moved in, the original tenant left, and Mr. Littlefield was there with his children. So same thing, I set the matter for a second hearing today. No rent was being paid, and I wasn't clear what the status is. Mr. Littlefield, what's your status here today?
I've been looking for a place. I've been in touch with Keystone. I mean, they were willing to pay all my rent for up to like 6 months, but he denied that. But they're still going to help me pay for a place to move to. But I'm trying to find something.
Is that correct, Bettina? Keystone would have paid rent, but they didn't want to accept it because he wasn't an actual tenant?
Not to my knowledge. We have other case managers here, so maybe he spoke with another case manager, and I'm unable to confirm that.
All right, well, here we have no lease. Mr. Rognus, you're simply asking for possession of the property back?
That's correct, Your Honor. And again, we had submitted a proposed judgment prior to the last hearing.
I have it. Same thing, Mr. Littlefield. You're in a tough spot. You got 4 kids. You're in there. You were willing to pay the rent. They don't apparently want that. This is a common theme this morning. The landlord simply wants the property back. In 2 of the previous cases, they wanted to sell the property, and I believe that's the situation here. I believe Mr. Persons wants to get the tenant out so he could sell it. But we had the first hearing. This is the second hearing. You're what's called a tenant at sufferance. There is no lease. You're a holdover tenant from a previous tenant. You have until June 7th to move, or you're subject to being evicted. Now, let me speak to that for a minute. Keystone is trying to help you find another place to move to. And it's hard right now to find a place to move to, here or anywhere else. They don't have to evict you on June 7th. They have 56 days from today to ask for the writ of eviction. But by the letter of the law, unless you're out by the 7th of June, the very next day, they can come and ask for a writ where the sheriff comes and puts you out. You've been there apparently since October when your father-in-law left. The matter's a little complicated because even though there's no lease, they did accept some rent from you. But at this point, the landlord does not want the rent. They want their property back and they want you to move. So you have until June 7th or you're subject to being evicted. I would suggest you stay in contact with Keystone. June 7th is a Sunday, so wait a minute. It's a Monday. So let's say you found another place on June 9th. Well, if you let your landlord know, hey, I'm going to move into my new place on June 9th, there's no sense to go through a whole eviction on June 7th. But what this type of hearing is about is really coming up with a drop dead date for the landlords to get their property back. And I had a case with a gentleman earlier this morning. The landlord's been trying to get him out for 1.5 years. And because of the COVID circumstance, they've been unable to do it. So I'm sorry you're in this position. I assume you want to stay in the White Pigeon area?
Yeah, yes.
And that's hard too. There are a lot of people looking for housing. And the thing is, every time someone gets evicted, there's someone waiting to move in. I think Mr. Persons wants to make improvements to this house and sell it. But that's the circumstance. You do have 10 days also to appeal this. If you appeal some issue that I'm not seeing, you could still ask for counsel, as I told you last time. Do you have any questions?
No, sir.
All right, you have 10 days to move or you're subject to being evicted. All right, good luck, sir.
Thank you.
Thank you.
Got it?
All right, that finishes you. We have 2 rendezvous with Rama cases here. We have Miss Hetherington, I think. And let's see who this is. Miss Hetherington, I can only see the top of your head.
Yeah, sorry.
I know you're short, but...
I'm very short, actually.
Mr. Rama, is that you? Mr. Rama? Mr. iPhone person? Or is that Ashley and Jeff? Mr. iPhone? Miss iPhone? I'm gonna kick them out. See if they come back. Miss Hetherington, are you still there?
Yes, I am.
I thought you were going to try to move.
Actually, we did.
All right, well, let's wait for him and then we'll put it all on the record.
But there's some, we still have some stuff over there, so that's
All
why
right, well, just wait a minute. We'll wait for him.
Okay.
You're going to get 10 days to get your stuff out of there. This case is set for 10/20. He's actually not late. We've got to let the clock tick a little bit. I'm not sure who iPhone was. One of these is set for 10/20, another set for 10/30. Tina, I think we have a busy day on Monday too. Let's take a look. Oh, Monday's, oh, we have a real busy day because Monday is Memorial Day and we aren't going to have court on June 4th. So we're going to be real busy on June 7th. All right, iPhone has joined us again. Let's see who this is. Good morning, can you hear me? It's hard to know when someone just comes in as a generic title. Mr. Rama, is that you? Well, it's not, it's 10/17. I don't know if it's the other defendant in the next case, whether it's this plaintiff, or whether it's just some random person. But that doesn't do any good. It's like a boulder in the stream. It's just a big block that says iPhone with no picture and no sound. Can you hear me? Erica, they spelled your name wrong on here. They've got it.
I seen that earlier.
It's Hetherington, is it not?
Yes, it is.
Heatherington. Is that correct?
No, it's HETHERINGTON.
Yeah, that's how I spelled it. Well, I don't know who iPhone is. We got one more minute. iPhone, I can't hear you, I can't see you, and there's no good for you to just be sitting there like a lump. So we need to figure something out. If that's you, Mr. Rama, see if I got a phone number. Yeah, the process server spelled your name right. The defendant or the plaintiff did this in handwriting, and his handwriting is so bad that they couldn't tell what it was, but I'm not in any position to criticize anyone's handwriting. Mr. iPhone, can you hear me? I don't have any phone number on any of his pleadings. Oh, I do here. Let's try this. I'm going to kick him out and call this number. Good morning. Is this Mike Rama?
Yes, sir.
Mr. Rama, you're going to have to get better at this. It's pretty bad. You're the plaintiff. You filed these lawsuits and you haven't figured out how to dial in. This is our second hearing. You don't have any video and you don't have any audio. Was that you on our feed as iPhone?
Yes, sir.
All right, well, if you can't figure out how to do this in the future, you're going to have to come over to the courthouse because you were just there as a lump, as iPhone. All right, well, let's talk about our first case. This is entitled Mike Naran Rama versus Erica Hetherington and all occupants. Ms. Hetherington told me that she has mostly moved. She is in the process of moving the rest of her stuff. Mr. Hetherington, did you give him your new address?
No, I did not. I don't even know my new address yet. The only thing I have there is my truck and my trailer. Everything is out of the room. It's just my truck and my trailer. My truck does not run, so I have to find somebody to get my truck to my new place.
All right. You have 10 days from today to vacate everything, and that would be by June 7th.
Okay.
Today's the 28th. 10 days from today is June 7th. You need to turn in the key to the room to him. Have you done that?
They don't give keys. They shut the keys off every 2 days for the doors to work.
All right, so they're electronic?
Yeah.
All right, so there's no need to return the keys. All right, she has 10 days from today to remove the remainder of her property. Otherwise, you can have it towed or otherwise removed. You understand, Mr. Rama?
Yes, sir.
All right. Okay, Erica.
Okay, now I have a question about my mail, because I got a letter from the IRS stating I was supposed to get a stimulus check, and everybody knows how the IRS works with the stimulus checks. If if you don't change your address through them before they send them out, you don't get them. So is there any way he can keep getting my mail until 10 days so I know I can get that stimulus check?
Well, yeah, that's still your mailing address for the next 10 days. So hold all of her mail, Mr. Rama, for the next 10 days.
Yes, sir.
Okay. All right, Erica, do you have any other questions?
No, I do not.
All right, thank you for making an effort to move. Get your stuff out of there and you're good to go. You got 10 days.
Okay, thank you.
All right, thank you.
Bye.
Mr. Rama, we seem to have gone backwards. Seems like when you were here last time, you managed to log in.
Yes, sir. So I'm not iPhone guy, but I can tell my son so he can join me.
Well, all right. Anyway, your son can't represent you, but if you can't do this next time, you're gonna need to come over to either get a lawyer or come to the courthouse and we'll put you in the conference room. Now, our next matter is not set until 10:30, so we have to, here's somebody, maybe this is the Catons.
Oh, all right.
All right, now stay here. I think the other people are coming in also by telephone. Good morning. This is Judge Middleton. Is this Ashley Caton and Jeff Hoff?
Yes, sir.
All right. Are both of you there?
Just me. Just Jeff.
Just Jeff? Where is Ashley?
Yeah. I don't know why she's on the case. She never did. Not with me.
All right.
They had the wrong name down on the paperwork.
Yes, they did. Defendant is present by telephone. Plaintiff is present by telephone. We were here on May 21st, which was a week ago, and you said you were going to try to move.
Right.
And what's your status now?
The problem is the money situation. I'm back to work now, but this is only my second week, so I'll have more money this week to be able to give me a different place to stay.
All right, well, you have until June 7th to move. That's 10 days from today.
Okay.
Will that work?
Yes, sir, absolutely.
All right. The first hearing, we're entitled, we have to have a second hearing, went through the advice of rights, and then there is no lease. This is essentially a motel room at very high rent. And don't pay any more rent there. Save your money to go to your next place. But you have until June 7th to move or you're subject to being evicted. Now, the keys are electronic. Normally, I tell you they have to turn in the keys, but my recommendation is you simply get your stuff out of there by June 7th.
I haven't had a key since I lived there.
Yeah, you're subject to being evicted. How do you get in and out?
Just put something in over the lock so he can't. The keys never work. I don't know what. He said to bend the key and put it in the door so it can't, so you can get in and out or climb through a window, one or two.
Well, that's not a great plan. So the sooner you get out of there, the better. All right, you
Yeah,
have
absolutely.
until June 7th to move, or you're subject to being evicted. All right.
All right.
All right, Mr. Rama, did you get all that?
Yeah, I got it.
All right, Mr. Rama, you could benefit from some legal advice. You need to get a proper lease. These are all screwy. You didn't spell the people's names right. You listed some of the wrong parties. They don't have a key to their own room, and they got bed bugs. So at any rate, both of these.
They got bugs, all kinds.
All right. Well, the sooner you're out, the better. If you're out by June 7th, you're good to go. All right, sir.
All right, thank you, sir.
All right, Mr. Rama, do you have any questions?
No, sir. I agreed until June 7th.
Okay, thank you. Now, if on June 7th, if you want them out, you have to come to the court with $15 and get a writ of eviction. You can't just put them out. You need a writ. But I think you could use some legal help. You've got a lot of tenants in there. You've got tens of thousands of dollars a month coming through there. And I think you could be better protected if you had a proper lease and some legal help. But that's simply my advice. It's not an order. But all right, you're good to go. And again, if you can't dial in next time, you're going to have to come actually to the court where we can see you, and we'll put you in a conference room. All right, thank you. All right, bye. All right, Bettina, thank you for your help. You can have Monday and Friday off. Take care of all your other stuff.
Yeah.
And I'll see you on June 7th.
Awesome. See you then. Have a great weekend.
All right. Thank you. You too.
Thank you.
All right. That finishes our landlord tenant docket. I don't know what else I have. I don't have anything scheduled for today, but I'm assuming there are some bench warrant arraignments or some other things for people that may have gotten picked up. Plus, we weren't able to accomplish anything yesterday because the power was out. So we may be trying to pick up the pieces on some of the cases from yesterday. At any rate, this is the last that I have scheduled for today. Monday is a holiday. We're going to be back on June 1st with a very busy